Actually, do we have to take any notice of what they've agreed?
We're live now.
Is that everyone in from the lobby? Right, well, it's 1 o'clock. Good afternoon, everyone. We're here for the Licensing Subcommittee, Alcohol and Regulated Entertainment for the 8th of December. But of course, you'll be aware that this meeting was adjourned on the 18th of November. So I'm going to start off by introducing myself and my fellow councillors. My name is Councillor Chris Cade. I'm the chair of the Council's Licensing and Safety Committee. And with me today, I have
Belinda Garcia. I'm the licensee, the councillor for the Revel and Binley Woods.
My name is Dale Keeling. I'm the councillor for Admirals and Corston.
Thank you, colleagues. So we'll move on to the agenda, part 1, public business, declarations of interest. So I'd like to hear any declarations of interest under item A, non-pecuniary interests as defined by the Councillors' Code of Conduct for Councillors.
No, thank you, Chair.
No, thank you, Chair.
Thank you. On to item B, pecuniary interests as defined by the Council's Code of Conduct for Councillors.
No, thank you, Chair.
No, thank you, Chair.
And item C, a notice under section 106 of the Local Government Finance Act 1992, non-payment of community charge or council tax.
Noted, thank you, Chair.
Yes, noted, thank you.
Okay, well, I can go with those. So that's all three of us. No declarations, thank you. So on to item 2. So, Marion, are you sorting out introductions?
Yeah, good afternoon, everyone. I think you've all met me via Teams. I'm Marion Allen, Senior Legal Officer advising the committee. If I could go around the screen and ask that people introduce themselves. Once they've done that, we will I will sort of set the order of who of the order of interested parties. I can see that Mr. Payne is actually here representing, I believe, 4 interested parties. Good afternoon, Mr. Payne.
Welcome.
Yes, good afternoon. Good afternoon.
I know obviously Mr. Gregory is here representing the applicants.
Yes, good afternoon.
And obviously Mr. Gregory will be outlining his client's case first. Can I identify the other interested parties? Good afternoon. I'm afraid I can't see you all. I think I saw, is Mr. Marsh here?
Correct, and my wife as well, Lucy Marsh.
Good afternoon.
As before, good afternoon. So I'll put you down for first after Mr. Payne. Is Mr. Sneed here?
Good afternoon. Yes, I'm here. Thank you.
Good afternoon, Mr. Sneed. Then I'll put you down for after Mr. and Mrs. Payne. Have I got Julie and Don Pennington?
Yes, I'm here.
Mr. Pennington?
Yeah.
Okay, good afternoon. Your third. Is there anybody else I haven't mentioned? Mr. Gregory, have you got anybody from the company with you?
Yeah, Thomas.
Yes, Mr. Palmer and Nick Hamer, the owner. Mr. Bromer.
Thank you.
Well, if that's everyone, good afternoon and welcome, everyone.
Thank you. Thank you, Chair. In that case, I have a list of all the parties I believe that are here. So the first proceedings will be for Mr. Gregory to outline his client's case. Over to you,
please.
Mr. Gregory.
Thank you.
Yeah, thank you, Chair. Thank you, Chair. Just before I do that, we've been in discussions with Mr. Payne and we have agreed some appropriate conditions to be attached to the licence. We did try and circulate those. Unfortunately, it was quite late in the day. It was only a few minutes before the hearing began, but we did circulate a PDF document with some agreed conditions on there. I was just wondering whether that had found its way to you or not.
I've got an email with a PDF in my inbox timed at 13:04, so literally in the last minute.
Yeah, I think it was sent just before, a few minutes before the hearing began. But clearly, those you may want an opportunity just to have a look through those. We've been in discussion over the last few days with Mr. Payne and his clients in relation to some measures that would give them the reassurance that they need, and it's taken up until this morning just to get those finalised.
And the intention in passing us this set of conditions is to shorten this meeting today, is it? Or what?
Yes, it's certainly, Chair. Clearly, there are other interested parties, but this, and I'm not sure whether they've had the opportunity to consider these, but certainly between the applicant and Mr. Payne's clients, these are agreed.
Well, the PDF that I've opened has got 11 points on it, and bearing in mind it's timed at 13:04, and some people will have it and some people won't. I don't know what you think, Marion. Is this something that we should have read out for everyone's benefit? Marion? You're on mute.
I know. Apologies. I'd actually got the conditions in front of the screen. I think it might be helpful if they could be read out for the parties and some little bit of a explanation. Mr. Gregory, would it be something that you could do? Read out the conditions, because obviously you and Mr. Payne have been in communication with each other. Perhaps if you could explain the conditions and the purpose of those conditions might be very helpful in what they're addressing.
Yeah, I'm happy to do that.
I've got them up on screen. I don't know if anyone else
has.
has.
Yeah, that's
over to you,
excellent.
Mr. Gregory.
Thank you. Okay, well, I'll run through them briefly. The first one, the premises licence holder shall ensure that the bar manager and personal wedding manager on duty at each event shall both have a current personal licence. So there'll be 2 personal licence holders on duty at each event. Secondly, no licensable activities shall be provided for the benefit of any person who has not been provided with a ticket or invitation prior to the event commencing. That's, of course, in line with the proposed use of the venue as a wedding venue. Thirdly, the playing of amplified or unamplified music and or vocals as entertainment. The sale and consumption of alcohol shall only take place within the ground floor of the existing building, and then it refers to the relevant plans. And for the avoidance of doubt, music to accompany a wedding ceremony may take place inside or outside, but will cease at 5 o'clock, and that is likely to take the form of a string quartet or similar to accompany a ceremony. Fourthly, noise from licensable activities or activities that shall arise from the conduct of licensable activities shall not exceed, and then it refers to the relevant decibel levels when measured at any point of the boundary of the estate. Fifthly, the licence holder or a nominated person shall regularly monitor the level of sound generated by licensable activities and regulated entertainment. And where action is required to reduce the sound level from regulated entertainment because it is likely to cause a public nuisance, then such corrective action will be taken immediately and recorded in the Daily Register. Number 6, a noise assessment. Well, this is the noise condition that we've discussed at length in previous hearings, so unless anybody particularly wants me to, I don't intend on reading through that again. Can we scroll down, Chair, to number 7? It's just not showing on my screen, thank you. External doors and windows of the building shall be kept closed while licensable activities are undertaken, except where they're being used for access or egress from the building. Number 8, no live or recorded music should be played outside, save string quartet or music of a similar nature shall be permissible outside to accompany a ceremony up until 5 o'clock. So that mirrors the wording of the earlier condition. 9, licensable activities shall only be conducted within the areas indicated green on the approved plan. Number 10, a telephone number shall be displayed at the public entrances to the Boughton Hall estate, which shall be clearly and conspicuously visible to persons outside of the estate. This number shall be monitored while licensable activities are undertaken, and reasonable endeavour shall be used to relates to the requirement for a premises daily register to be held at the premises, and the bullet points underneath deal with what that register must contain. and that is the name of the person responsible for the premises on each given day. Any refusals of service on grounds of age and/or intoxication. And if we just scroll down, Chair, thank you. Regular checks of the CCTV to ensure that's operational. And then below that, the designated premises supervisor shall check the premises daily register on a weekly basis, ensuring that it's complete and up to date. He shall sign the premises daily register each time that it's checked and make it available for inspection by the council's officers throughout the trading hours of the premises. Condition 12 relates to written policies and procedural statements that must be drawn up by the applicant, and the bullet points there just set out what those policies must relate to. So CCTV, conditions of entry, dispersal of patrons, safeguarding children, noise, queue management, responsible service of alcohol, security measures, underage sales and false identification, and zero tolerance for drugs. The policies must be reviewed in the event of concerns being raised by the responsible authorities. Changes to the policies or procedures must be documented, and the premises licence holder shall ensure that all staff employed at the premises are aware and understand the policies. Number 13 relates to photographic proof of age being required from anyone who appears to be under the age of 25 years old and who is seeking to purchase or consume alcohol on the premises. If you could scroll down, Chair, thank you. So condition 14 relates to the display of clear and prominent notices at all exit points to advise patrons of the needs of the local community and acceptable behaviour in public spaces. Condition 15 requires the organisers of the events, weddings, and this means, say, the bride and groom in the case of a wedding will be provided with instructions, with instructions concerning arrival by motor vehicle and parking for onward distribution to the invitees before they commence their journey. These instructions will indicate the arrival route and that parking must only take place within the Boughton Hall estate. 16 also relates to parking, and that requires the licence holder to ensure that sufficient provision for parking is made within the grounds of Boughton Hall for anybody arriving at events by car. 17, the licence holder shall ensure that a member of staff is on duty from 11:30 p.m. until the time when the last non-resident leaves the premises. Where deemed necessary or appropriate, that member of staff will remind patrons of the need to leave in a quiet and orderly fashion. Number 18, importantly, all licensable activities must cease by midnight on every day of the week, save for wedding events held on New Year's Eve, when the activities shall cease at 1 a.m. on New Year's Day. So that represents a shortening of the hours from what was applied for, from 1 o'clock on Fridays and Saturdays back to midnight. And finally, persons who are not residents are to be vacated from the premises no later than midnight. And I've just picked up, Mr. Payne may have a comment, but in relation to that final condition, it's not. There will need to be a carve out there for New Year's Day to mirror condition 18, so that might need to be half an hour after 1 o'clock, I would suggest. But you'll see, Chair, there has been considerable efforts made by my clients to address the concerns of interested parties, and we feel now that these are a sensible and appropriate set of conditions that we can move forward with.
Okay, thank you. Marion, how do you think we should proceed in the light of this late submission?
Apologies. Well, obviously a lot of work has gone on between Mr. Payne and Mr. Gregory, and I think the subcommittee and the council are grateful for that. It obviously, in effect, your clients, Mr. Gregory, accepting those conditions should the premises licence be granted with all those conditions. Yeah. Can I clarify with Mr. Payne? Is that if you're in agreement, Mr. Payne?
Yes, if I can deal with it this way. What has been agreed are these sets of conditions, and this represents an amendment to the operating schedule that forms the application before you. So it's not a document that's being submitted late. It is an amendment to the application, and you'll be aware that there is significant case law on this, including, I think, T&G Bars in Manchester, where an application was amended during the process of the hearing. We are entirely content to accept these conditions. What I will say is that those that I represent still have grave or reservations, I should say, about what might happen at these premises, but this is seen as a pragmatic and positive way forward to allow the prospective licence holder to demonstrate that they can run a business responsibly and successfully. And of course, if things should go awry, then there's always the process of review. But it's seen as a pragmatic way forward, and we would accept these as an amendment to the application.
Thank you, Mr. Payne.
My Chair, if I can just mention, obviously there were conditions that had been accepted, that had been suggested by the responsible authority, namely the Environmental Services section of the council. I haven't got those to compare at the moment, but obviously I think my recollection, and the licensing officer may be able to assist me on this point, I think they probably encompass those conditions these go further. However, Chair, there is also the point that there have been some suggestions made by the Environmental Health Officer following the noise assessment, which I don't know how would fit in with those, but I don't think it's an issue. I think they're probably covering most of the points that were raised there. So in essence, we've got Mr. Payne saying that as far as his clients are concerned, whilst they still have some concerns, provided that if the premises licence was to be granted with these conditions, it's a way forward. And as you rightly say, Mr. Payne, any of the residents would have the right to review if there were problems and the applicants, Boughton Hall, weren't operating. They've got the right to a review. So from your point of view, you're in a position to say, provided these conditions or the amendment to the variation to the operating schedule with the conditions is attached, that would remove your objection at this stage. Is that right, Mr. Payne?
Yes, that would satisfy the representation, of course. I mean, we will stay for the hearing because, of course, things can occur during a hearing, which could change the position. But yes, that is essentially the position. I hope you find that helpful. I'm conscious we did propose a significant number of conditions at the very beginning of the process, and you'll see that there are some stark similarities between what we originally proposed and what we have here. However, we are grateful for the applicant and for the work of Mr. Gregory, especially in trying to negotiate some agreement on a set of sensible conditions going forward.
Thank you.
Thank you, Mr. Payne. I'm sorry. I'm sorry, Chair. I keep butting in on you, and I do apologise. But obviously, we have other interested parties here. Now, I think we need the agreement of how we go forward with this. Obviously, those interested parties have not seen these proposed conditions before. They've obviously heard them like we have the first time, and they need to make any comments they have with regard to would it address their concerns and their objections that they have raised, and perhaps that might be the best way to actually ask that question first. If these conditions, the proposed conditions, were applied and that the amendment to the variation to the operating schedule, would they be in agreement with those conditions being attached? And would they be prepared to take the view that Mr. Payne's clients have? So I think perhaps we'd better ask that question first if everybody's in agreement. Mr. Gregory, do you think that's the way forward?
Yes, that sounds acceptable.
Chair, with your agreement, are you?
Yes,
happy?
absolutely. That's for where we are now. That's the way we need to go. Absolutely.
So if I turn to Mr. and Mrs. Marsh first, have you any comments to make in regard purely on the conditions proposed? How would that make your objection?
Yes, I do have some comments. Sorry, yes, I haven't seen these things, so I'm just having to sort of take them on board now. But the there are two aspects that really concern me: it's the time and the numbers. As far as I can see, the condition didn't say anything about the maximum numbers. But returning to the time, it's a relatively small concession here. We've changed, I think, 2 or 3 nights from 1 to 12, but it's midnight throughout the year. Otherwise, apart from New Year, I don't mind about New Year. I'm really not happy about going beyond midnight, and essentially this thing is not going to be over until 12:30 in terms of people leaving. So if there's any chance that could be moved a bit earlier, I mean, I think I said 11 in the document I submitted, but I mean 11:30 would be reasonable. If people could start leaving 11:30, then it's all over by 12, and that would really help a lot here. This is straight in the middle of our village where nothing really happens at that time. So I'm not terribly happy about it going to midnight. And then the other thing is, I don't know what the maximum number is. On the site, it talks about 250 people in the evening. Is that still the aim? That's really a lot. That's 200 cars running when we normally have 1 or 2. So this is a serious impact. I realise that may be outside your remit, but those are both the 2 significant points for me. So I'm not. I think the midnight is my particular point, but since it hasn't said anything about the numbers, that's a concern as well.
Okay, thank you for that.
Shall we move to Mr. Sneed? Have you got any comments with the conditions?
Well, my main concern that I have with this application is around the use of fireworks as a health and safety issue. I've written to the committee highlighting my concerns about repeated use of fireworks in that particular area, and the risk that it may represent both the local community and the wider community through the contamination of drinking water at Draycott.
Mr. Sneed, can I interject? The fireworks issue isn't one of the licensing objectives. That can be dealt with through statutory and other powers. I'm sure Mr. Gregory, Mr. Payne will agree that the whilst I acknowledge your concerns, they are not an issue that can be considered by the licensing committee to deal with this application.
So I'm a bit confused, because my understanding of the Licensing Act in 2003, as amended in 2013, is that the entertainment has been defined as an event that takes place in the presence of an audience for the purpose of entertaining the audience. So I'm not quite sure why this is not a licensable activity, particularly when it's being used in conjunction with what clearly is a licensable activity in the form of alcohol and live music as well.
Mr. Sneed, I have sought the views of the responsible authority who would deal with this, and the answer is that this is not something that that should be dealt with under the licensing application.
But this still represents a health and safety risk which needs to be addressed.
That can be addressed by other methods, not under the licence.
And the reason why it's not so would it be fair to say then that the licence should state that the use of fireworks is not permitted?
Mr. Gregory, it might be an opportunity for you to respond to that.
Well, our position on the fireworks, I think the safety of the fireworks is perhaps not relevant. The noise from fireworks are addressing submissions, but yeah, I mean, the concern about fireworks has been picked up by us in terms of noise. But yeah, I think the safety of the fireworks is not a concern of the licensing authority.
But the other point I'd make is that the fireworks were included on the public notices around the licensing, or as it was then, extended licensing application. So I'm a bit confused as to why it's suddenly now not part of it. And in any event, it's really a health and safety issue, which I think we need to be aware of. And I'd like to have some reassurance that it's going to be addressed. If this licensing does indeed not cover the fireworks displays, then that should be clearly stated, I would have thought, because that was what was advertised in the village when the application notice was first put forward.
Thank you, Mr. Sneyd. I think all that the committee can do is note your concerns.
Noted.
turning to apologies, Mr. Pennington.
Hello. I do not withdraw my objection that I stated in my original letter to the council. I think the licence should only run till 11 o'clock in the evening on weekdays, and then exceptionally to 12 o'clock on a Friday and Saturday night. I also think there's a serious noise issue late at night from people in the grounds of Bolton Hall slamming car doors and shouting whilst they're drunk at each other as they leave the village. And then there's the noise through the village from cars racing away to get to wherever they're going. I would also like the support of the licensing committee, although I understand it's not within their remit, but I would like some kind of support, if it was possible, to make an application to have a 20-mile-an-hour speed limit through the village, and for the villagers to be able to apply to have their own speed guns, as other villages have done around the country, and to then talk to our councillor to progress that.
Thank you, Mr. Pennington. I take your comments, but I'd have to actually, I'm responding on behalf of the committee to say that obviously that is the county council who deal with matters like that, and obviously we note what you say. Thank you.
But I'm just asking for the support of the committee, not for them to say that it should be done.
I think that's something that the members would have to decide individually. It's not part of this panel. Okay.
The final thing I want to say is that I think Rugby Council is pretty rubbish. I made a complaint over 3 weeks ago about one of the council members who still seems to be there, and I've not heard back from that complaint. And my wife made a complaint at the same time over 3 weeks ago about your breach of the Data Protection Act. I've had nothing back at all from the council. I'll mute yourself.
Sorry, I have spoken to our monitoring officer, and that is dealt with separately. And obviously this committee and its members cannot make any comment in regards to that. But I have noted your concerns.
Okay, that's all I want to say. Thank you.
Thank you, Mr. Snee.
I have nothing more to say, thank you.
Chair?
Yes, Marion?
I'm just thinking what position we're in. I'm sorry, we've slightly gone, obviously, in light of the late arrival of the conditions. There's no criticism there. They've been very, very helpful. But with Chair, I think perhaps now it's the opportunity for Mr. Gregory perhaps to, I think, summarise it all. The interested parties, I think, have stated how they still feel, and obviously the committee take that on board. But I think this is the opportunity for Mr. Gregory to fully state his client's case in view of these conditions, the application, and then we'll move from there to any comments.
OK, well, thank you for your advice on that one. I quite agree. I'm happy to proceed with Mr. Gregory summing up.
Well, thank you, Chair. So I'll just briefly outline the background to the application. You can see from the plan that the premises to be licensed are essentially consist of Bolton Hall itself, not any part of the grounds or the outbuildings. Members are probably familiar with it, but by way of background, Bolton Hall is a Grade 2 listed building dating back to 1791, which includes a former Catholic chapel. It sits within around 16 acres of gardens and parkland. On the north side of the hall is a large car park with around 120 car parking spaces. Both the hall and the chapel have been vacant, and the building was last used as commercial offices until the premises were purchased by Country House Weddings late last year. And Country House Weddings is the parent company of Bolton Hall Limited, which has made the application. Country House Weddings is a specialist wedding venue operator, runs similar venues throughout the country, brings with it a wealth of experience in that respect, and for want of a better word, it runs, shall we say, upmarket wedding venues. So as you can see from the plan, the ground floor of the premises consists of the reception and entertaining areas, including the dining room, main bar and disco area. The first and second floor will be solely guest accommodation, and there are 15 guest bedrooms altogether. Licensable activities are confined to the main bar and the bar disco area of the premises, which you can see shown edge green on the plan. And in this area, there will be the sale of alcohol from the bar, and the provision of regulated entertainment, which will primarily be music, and the sale of late night refreshment. Essentially then, it's the usual kind of licensable activity that you expect to find at a specialist wedding venue. In terms of the hours applied for, they're fairly standard for a venue of this type, being the supply of alcohol and provision of late night refreshment between 11 a.m. and 1 a.m, subject of course to the restriction now agreed, pulling that back to midnight every night of the week. Now, my client is fully aware of the importance of the licensing objectives, and I'll turn briefly to address those in turn. So I propose to limit my submissions to the objectives which are at issue here, and I think those we can agree are the prevention of public nuisance, prevention of crime and disorder, and the promotion of public safety. I don't think any of the parties are putting forward representations in respect of the protection of children from harm, so I don't intend to address that unless there are specific matters arising. So turning first to the prevention of public nuisance, importantly, the relevant responsible authorities as far as nuisance is concerned is the Environmental Health Department, which has deemed the application acceptable on the basis that 3 conditions were imposed, and those conditions were firstly the playing of amplified or unamplified music shall take place only within the ground floor of the building as marked on the plans. Secondly, that when music is being played, external doors and windows shall be kept closed except for ingress and egress. And finally, that a noise assessment is required to be undertaken prior to occupation of the development. And so the applicant has agreed to all those conditions, and on that basis, Environmental Health withdrew its representation and is satisfied with the application. As regard the third of those conditions, relating to the noise assessment, you'll note that that was only required to be submitted after the grant of the licence, but as we've discussed, it was submitted earlier than this in the hope that it would provide some reassurance to members of the panel and to members of the public. And just, I'm not going to take you through that noise assessment in any detail. I'm sure you've had an opportunity to read it, but just turning to the findings and conclusions at paragraph 2.3. The report states that the music hall developed within Boughton Hall is substantially screened from dwellings. The building provides good attenuation of sound, reducing emissions to a low and readily acceptable level. 2.4 states that the distance of the music hall and its screening by the main hall building means its emissions were inaudible, even when internal levels were substantially above those normally used beyond the boundary of the site. And 2.5, low frequency bass emissions and also lyrics, which are the main cause of potential concern, would be well below minimum audible thresholds at the dwellings located in all directions. And turning to people leaving the premises, 2.9 is relevant. Noise from guests leaving this type of venue can become an issue at some sites, but the significant distance to the car park and the ability to further mitigate this noise if needed provides significant assurance that it will not be an issue. Now, sir, as well as the professional noise assessment, I would draw your attention to the aerial map, which I think was produced by your officers, and this shows the location of properties belonging to those who have made representations. And it has to be said that even without the benefit of a professional noise report, it's clear that most of these properties are some distance from the premises. In fact, Boughton Hall is situated, I'm instructed, approximately 90 metres from the nearest residential property, Park Farmhouse. And even that property is located on the other side of the building to the bar and disco. And I don't propose again to labour this point by taking you through each of the properties in turn. They're apparent from the plan. I simply invite you to draw your own conclusions based on their location and their relationship to the premises. But this is, I think the important point here is that this is not an application where we're dealing with a bar or club surrounded by residential properties in the immediate vicinity. Now, as well as music, we've just referred to the use of fireworks, which is raised in a number of representations. In this respect, the applicant is going to use the quieter whisper fireworks, which are also lower, and even these will only be used up until 9:15 in the evening. And it's also relevant that the ground level where the fireworks will be operated from is at the rear of the property, and it's lower than the level of the road, and it's on the side of the building that's furthest away from Main Street in the village. So it is the applicant's view that they will only be partially visible, if they're visible at all, from outside the immediate vicinity of the premises. The other thing to stress in relation to fireworks is that the proportion of guests who opt for fireworks at weddings, I'm told, is a significant minority, and it's certainly not the case that there will be firework displays on a daily basis. In summary on nuisance then, Chair, members have the professional views expressed by Environmental Health. They have the professional views expressed in the noise assessment carried out by MAS Consulting, and they can be fairly reassured in my submission by the distance of Boughton Hall from residential properties. In my submission, Chair, the refusal of this application on the basis of noise nuisance is unsustainable, particularly with the conditions that have now been agreed with some of the interested parties. Turning briefly to the prevention of crime and disorder, again, it's notable the relevant responsible authority, Warwickshire Police, is content with the application. It's made no representation. In my submission, there's no evidence that this premises will lead to crime and disorder. Really, this is limited to assertions that alcohol leads to crime, rather than any evidence that this particular premises will cause an issue with either antisocial behaviour or crime and disorder. In this respect, though, it is a condition of the planning approval that CCTV will cover the full extent of the access road, and staff will receive training in how to deal with intoxicated or disorderly guests. As to crime and disorder caused by people leaving the premises, well, I'll draw your attention in this respect to the Council's licensing policy, paragraph 8.10, which provides that once away from licensed premises, a minority of consumers may behave badly or unlawfully. There are other mechanisms, both within and outside the licensing regime, that are available for addressing such issues. And now, so my submission, that policy is exactly right, and it has to be remembered that this is a venue that provides accommodation where people are likely to stay overnight, or alternatively taxi to pre-booked accommodation or back to their homes, which is usually the case at wedding events. It's wholly different in this respect to a pub or club, where people are likely to leave at various times and walk through the village, perhaps trying to find other licensed premises, or walk back to their homes. This is simply not going to happen here, and there is really very limited scope for crime and disorder arising from people leaving the premises. Finally, then, the promotion of public safety. As regards public safety in the venue, there was a representation from the fire service. This stated that the doors on the bar disco area and the main bar will either need to be changed or to outward opening doors, or the occupancy of each room limited to 60. And in response to this, the applicant intends to alter the doors, but it is content to accept a condition which restricts occupancy of those rooms to the levels suggested in the event that the doors aren't or can't be changed. And so I think that deals with that point. So that's all I have to say in relation to the objective strictly. There are some residual matters which have been raised by the interested parties which don't fall neatly into any of those categories, and arguably should be disregarded for that reason, but I will address them briefly for completeness. Firstly, traffic and pollution, which is essentially a planning matter. A transport assessment was provided during the planning process that demonstrated that vehicle trips from the site are unlikely to have a significant impact. In addition, it's anticipated that over half the attendees at weddings will choose to stay overnight using on-site accommodation, thereby limiting traffic levels in the evening. Refusal based on traffic would be unsupported by the evidence. And whilst on traffic, the possibility of drunk drivers leaving the premises are mentioned, but this is a criminal offence dealt with using the criminal law, and quite apart from that, there's simply no evidence that these premises would have a particular problem with drink drivers. Weddings are generally not impromptu events. Most guests would have arranged transport or accommodation. So litter is mentioned in some objections. Again, no specific evidence has been forthcoming in this respect. There is, of course, no takeaway option here, and so problems with litter would seem unlikely. There's one representation in relation to nesting wildlife, again, not relevant to the licensing objectives. That said, the county ecologist was consulted in relation to planning, and his response that there'd be no adverse impact on biodiversity. So there were a number of other objections which related to the need of the premises and saturation of the local market. But as your officers have pointed out, again, these are not relevant to the licensing objectives and must be disregarded. So in conclusion, members, this is a case where there's simply no evidence that any of the licensing objectives would be undermined by the grant of the licence. The responsible authorities are satisfied with it, with the proposed conditions. And in my submission, there's no evidence that would lead members to draw a different conclusion to those responsible authorities. Members will be aware that this is an application that will bring economic advantages and jobs to the area, whilst ensuring the restoration and preservation of a listed building. And this is, as you'll be aware, testing time for the licensed trade and for wedding venues in particular. In my submission, care does need to be taken here not to burden the business with unduly onerous or bureaucratic restrictions and conditions. And I think those that we've agreed with some of the objectors strike a reasonable balance between the interests of those objectors and the economic interests of the operator. And so I think you should be very reluctant to go any further than those agreed conditions. So for those reasons, we respectfully invite you to grant the licence in accordance with the agreed conditions. And unless I can assist you further, I have nothing more to say at this stage. I would add that should you wish to ask my clients questions, they're more than happy to answer directly.
Thank you, Mr. Gregory. Mr. Sneed, I see you've had your hand up for quite a while.
Thank you, Chair. Yes, I just wanted to come back to my concerns about fireworks since they're raised by Mr. Gregory, and want to point out, obviously, that the use of modified fireworks does not in any way affect the toxic effects that fireworks have on the environment. And I wanted to be I understand it's been noted, but I wanted to be assured that the Environment Agency, or whoever it is that's adjudicated on the firework issue, has seen light of my concerns, which I did submit to the committee, because I haven't had a reply back as to say what's happened to that information.
Marion, any advice specifically on fireworks?
Correct me if I'm wrong, Miss John, but John Illingworth, John McTurn, sorry. It was sent to the environmental health officer who dealt with this, and and as I say, he said it wasn't a licensing objective, the other things. So the reply was given. So he is aware.
That's correct, Marion.
That reply has not been given to me.
I'm sorry, Mr. Sneyd, but it was an objection that was you sent in, and it was for consideration by the committee, and the answer's been given.
Well, I'd quite like to see the answer all the same.
I will deal with that separately after the committee.
Thank you.
Okay, Mr. Marsh, you've got your hand up.
Yeah, I don't know if I'm going to get a time to comment more fully on what's just been said, but there are some aspects of what Mr. Gregory has said which I quite strongly disagree with. Are you going to have an official round of comments, or how are you going to manage it?
You have the floor at the moment, Mr. Marsh.
Okay. Well, so I wasn't going to talk about this because I'd put it in my submission, but Mr. Gregory raised it. He's again tried to give this impression that there's going to be practically no noise from the thing, as the noise report gives. And I'll have to say it because I said it in my submission, there is no measurement of the noise background has been made. There is no credible measurement in that report. There's an estimate just based on what might happen at some time. And until that's done, we just cannot judge anything from the noise report. And then we're also then being told that the noise of the car park can be somehow managed by one person telling people to be quiet. 200 people leaving a venue, going to their cars. Does anyone really believe that they're just going to take the word of someone saying, please be quiet? This is just not credible. And so if anyone can tell me that they really think I'm not going to hear noise from that car park, I'd like them to state their name and just tell me, and we have a bet on it if you really want. There's absolutely no way I'm not going to be hearing this stuff. And so the key conditions are the time. Again, I say it again, when does this whole thing stop and how many? We haven't said anything about how many people are going to this venue. These are absolutely critical. And then finally, Mr. Gregory raised it about fireworks. They're either a problem or they're not, okay? And so if you're starting to say that only a minority of guests are using them, you clearly know that they are a problem. I mean, so, you know, are we going to hear noise from fireworks or not? It's quite clear that we are, and you're trying to sort of say it's okay because just only a few people are going to use them. So let's not
on which basis, actually, one might as well say, well, then it won't harm you not to offer them.
So you know, I really think this noise report, which is concentrated on the music, is essentially concentrated on things that doesn't really matter, and what you've said about traffic noise and car park noise is, you know, it doesn't give me much hope here at all. There wasn't really anything in that report of any technical nature as to how to reduce that noise. It just said some stewarding of a car park as possible, and there was no clear idea of how to actually do that. And I just don't think that one person, you know, stewarding a car park is going to get rid of that. And as I say, finally, numbers. Can we absolutely agree on a hard number on the number of people in these evening events?
Before we move on from that, because we're both speaking from one address here, so to speak, there are a few points I'd like to make. Mr. Gregory mentioned the other venues owned by the parent company of Boughton Hall. None of them, unlike Boughton Hall, are embedded in the heart of the village. Boughton Hall can only be reached by the single road along which the village is built, and an aerial photograph does not give you any notion, any more than the one afternoon that Mr. Stigwood spent here, of what living in the village is actually like and how noise travels across the field around which many of the houses are clustered, with Boughton Hall facing us on one side. We live adjoining it. Activity there can always be heard. As villagers, we respect each other's need for quiet, and we know how sound travels, and so we all keep it down. But I don't believe there will be much, if any, leakage of sound from within the hall. I am really concerned about the sounds that will come at the end of the night, very, very long night that's anticipated. And we've heard reference to the travel report that was submitted with the original application. It made a very false parallel with the business that was run there previously, Practical Action, which operated during the normal office hours of a normal working week, not throughout the week, not into the middle of the night. Boughton Hall seeks to operate through the entire week into the dead of the night, with some guests travelling by taxi, fair enough, but that means they will have 4 journeys associated with their one visit to the hall. The taxis bringing them and departing and then coming back to get them and take them away again. Now, the author of the sound report, Mr. Mike Stigwood, also co-authored a paper called The Assessment of Potentially Actionable Noise Impact, which gives rather more time to the question of the effect of noise at night than the sound report itself does. In it, the authors discuss the question of intrusive sound emanating from a neighbouring source, noting that noise should not be considered in isolation, but in the context of wider situational factors, that noise disrupts any activity such as relaxation and rest to a greater extent than activities requiring higher concentration, such as you would have during the day, so that a relatively quiet dripping tap might be thought of as not annoying, but can prevent or disturb sleep in a bedroom at night. Now, I rather think that, as they say, that can become a serious annoyance. The sound of people leaving the hall and driving through the village at past midnight and even, you know, on to 1 o'clock maybe, because of staff having to leave as well, will be rather more than a dripping tap and out of our control. We have no objection to Boughton Hall running as a wedding business, of course, but it really cannot be stressed how much this will affect our lives. The report noted the significant tranquility of the village, which is going to be massively disrupted by these events. And fair enough, you know, as long as it's at a reasonable time, one has to accommodate that. I've looked at a number of wedding venue sites and what they allow, and I really don't think it would be a severe imposition on the business of the hall to limit their licensing hours to 11:30 throughout the week and at weekends, most particularly when you consider that they have chosen to situate their business here. We didn't ask them to do it. They bring no particular amenity to the village, though they mention that they will bring business. We gain nothing and we lose an awful lot. So I would submit to you that 11:30 ought to be the closing time every night. That's, I think, all I have to say on it, but thank you for your time.
Thank you. Marion, could you just clarify for the benefit of objectors or other witnesses here today, the difference between the determination we need to make under the Licensing Act and how noise is dealt with under health and safety legislation?
Thank you, Chair. As everybody is aware, that the determination of this application is in line with the 4 licensing objectives. I don't propose to go into those. Mr. Gregory has outlined them very clearly. And as Mr. Payne said earlier, that as and when, if they were to be granted this licence, as and when the company were operating, if there were any issues arising from that they weren't complying with conditions or anything, then any person can ask for a review, and that with the evidence of the problems. And you clearly know that at the moment there is no evidence of any problems because they're not operating. Likewise with noise, if there is an issue, there are statutory powers. The environmental health officers who have the powers to take action to serve an abatement notice, and if that was to be breached, to take a prosecution against anybody who has been served with breach with an abatement notice. So clearly there are other powers outside the remit of the licensing act that can be dealt with, but the committee are determining this in line with the 4 licensing objectives.
Thank you for that summary, most useful. We've got a hand up in the Pennington box.
Yes, thank you very much. It's a clarification I have to ask, really. The diagram shows within the building where alcohol will be allowed to be consumed. What will happen when guests want to go outside, which they undoubtedly will, to smoke a cigarette or to get some fresh air? Will they be allowed to take alcohol outside with them? My understanding is that not, but will they be allowed, and what measures would be taken to stop that happening?
I suppose, Mr. Gregory, that's one that you may be kind enough to address.
Yes, at present, there's no condition restricting drinks from being taken outside, but clearly all the other conditions remain.
Well, I thought that drawing a boundary around the hall about where you can drink alcohol means that you can't take it outside.
Well, the boundary relates to the licensable activities, which is the sale of alcohol, but not the consumption.
On the second point, My understanding is that when it's fully developed, Bolton Hall will have something like 70 to 72 bedrooms. But when we spoke with the owner a year ago, our understanding was that that wouldn't happen for perhaps 3 years. So your claim that over 120, 140 people will be staying overnight will not happen in the immediate future.
Okay, we've got a hand up in the Marsh box as well, please.
Apologies, I hadn't taken it down.
Right, thank you. Does anyone else have anything they wish to raise? Back to Mr. Pennington, was it? Or is that the same hand? Okay, Marion, advice please as to how to proceed.
Thank you, Chair. I think everybody has now confirmed their objections or raised the questions they want to. Mr. Gregory has outlined. Mr. Payne has kindly gone through his position with regard to his clients and the conditions. You have the conditions before you. Obviously, you have the previous conditions the Environmental Health Officer had suggested. As I said earlier, I think they're covered by the new conditions, but haven't had the opportunity to look, nor have the licensing officers. However, the decision, because this is virtual meeting, the decision will not be given today. The decision will be given in writing to give the members an opportunity to consider all the points raised by all the parties, and that decision will be given within 5 working days. But that is the position. We're not actually giving the decision now. Unless anybody else has got anything else to say, I think Mr. Gregory he did his application and summary in effect all in one. I think that's probably the end of the meeting, unless anybody has anything to say.
Mr. Payne's got his hand up.
Chair, yes, I'm grateful to that. I'm conscious that we have perhaps wandered off the procedure a little in this particular hearing, but I just wanted to draw attention to some points that have been raised and perhaps need to be reinforced. The first is in relation to the representation from the fire service. Now, we've deliberately not included anything in the agreed conditions about capacities because you have it there. And as Mr. Gregory pointed out, you are within your rights to actually attach a condition in relation to the fire service representation. And that could quite clearly be, or very simply be, that the capacity for each of the indicated rooms shall be no more than 60. It is then available to the applicant to come along and seek a minor variation if indeed they are able to amend the doors to vary that condition. And that's the way that we would suggest that goes. Now, I'm conscious that lots has been said about fireworks and noise. I am aware that there are other provisions like the Firework Regulations 2004, the Noise Act. These all go to provide additional protections, and your legal advisor is right that there are powers there available. But the point that I think is relevant is this one about the fire safety, and we would suggest that that is indeed a condition that you should attach, as I think has been accepted by the applicant's representative from their representation.
Thank you. And the hands up in the Marsh box again.
Yes, I just wanted to ask once again about the numbers. Will there be a discussion when you make your decision about the maximum numbers?
I'm sure that's likely to come up in the discussion. Yes, I would imagine so.
Okay, thank you.
Mr. Gregory.
Yeah, just to clarify on the fire service point, we would be willing to accept a condition either that the capacity is restricted to the 60 in each room, or the doors are changed to outward facing doors in compliance with what the fire service have requested, but we'd like both options.
Thank you. So Marion. Oh, sorry, Mr. Marsh, are you there again?
Sorry, usual Teams problem.
Right, okay, thank you. Marion, so where are we now? Are we at the end and it's deliberation time?
I believe, Chair, that in light of what everybody has said, that you have your options and it is deliberation time. So the rest, the meeting is now closed. You can close the meeting, Chair.
Thank you very much. I wouldn't disagree with my learned colleague. The meeting is closed. Thank you very much.